Wait, so you can hire someone to kill your wife and consent for the killer to be released? Okay. Sonny. I know your divorce did not go the way that you wanted it to. No. No, Sonny voted for this fucking DA, didn't he? Hey, everybody. How's it going? I think it's very important that a lot of the people that are asking certain questions in my comments read the source document that they're referring to. So a question I've been getting all the time now is, what do you think of the new New York City District Attorney saying that he is not going to prosecute all of these lower level crimes? What do you think of the fact that somebody may be able to get away with burglary or robbery and not get prosecuted at all? And that's been a lot of what's in my comments. That's not exactly true. They are still going to be prosecuted, but there will be the opportunity to be prosecuted as lower offenses. To be clear, I'm not saying I agree with it, but what I wanted to do was read how it was being reported in the news, read how it was being reported in my comments, and then read the actual memo. I think it is very important when it comes to things like this that you have a strong distrust for commentators and a strong distrust for the news, especially a strong distrust for me. What you should trust is the primary source document that everybody else is referring to. So don't trust me. I don't know what the hell I'm talking about. I'm not a legal scholar. I don't know anything about the justice system. Don't trust the news. Read the source document and figure it out for yourself. So I thought it may be interesting if we read the news and then we read the source document and just try to dig into what it is that the policy actually is. Let's see. New York City District Attorney recent statement. Let's see what we got here. Daily News, Pick, CNN. What should I trust here? You know what? I'll read CNN's take just because I want to see what the left-leaning take on this is. So that nobody accuses me of a bias. Among crimes, Bragg said his office would not prosecute marijuana misdemeanors. That makes sense. Who cares? I don't give a fuck if you smoke marijuana. Like, as long as you're not driving, I don't care. Not paying public transportation fare. Fuck the MTA. You have people making $400,000 by scamming overtime. If the people who work at the MTA can scam the MTA, why can't I? Trespassing except a 4th-degree stalking charge. Okay, that's kind of not cool. Resisting arrest. Obstructing governmental administration. What does that even mean, though? What's the backstory on the chair? It's a fucking chair. Why do people keep asking that? What is the story of your chair? There's no story. It's a fucking inanimate object. You go to Amazon.com, you would add to cart. It shows up, you sit in it. Like, that's the third time that got asked in the Scream, and thank you, I appreciate the $5, but what do you mean story? It's a chair. It's like, what's the story of this water container? What's the story of this remote control? There's no story. I use it to turn shit on and off. Misdemeanor offenses that are legally required to be given a desk appearance ticket will be offered diversion or community-based programs intended to help an offender. He wants to reserve pretrial detention for very serious cases. By pretrial detention, you mean people going to jail. What's that language? Pretrial detention. You mean people going to jail. Okay, so for what? He intends to limit underage defendants in adult courts. Bragg also outlined a policy to request a partially unsecured bond in the same amount as cash bail request. Safety is paramount. New Yorkers deserve to be safe from crime and safe from the dangers posed by mass incarceration. Okay, so I'm going to continue reading this article. Focuses on reducing recidivism. Police officers don't want to be sent out to enforce laws the district attorneys won't prosecute. PBA President Patrick Ling said in a statement on CNN. And there are already too many people who believe that they can commit crimes, resist arrest, interfere with police officers, and face zero consequences. So the resisting arrest thing, like, I get it. Not prosecuting that is going to embolden people to like say, I'm arresting you. Fuck out, like just punching the cop and getting away. Let's see. These policy changes make us safer. They'll also free up prosecutorial resources to focus on violent crime. The DA wants to invest in alternatives to incarceration. Like what? Like his focus will be on accountability, not sentence length. Research is clear after blah, blah, blah. Okay. DA won't prosecute so they can claim low crime rate. Well, again, what is it that they're not prosecuting? I want to read the whole article. So, like, in the beginning here, it's talking about, again, marijuana misdemeanors. To be clear, I don't give a fuck if you smoke weed. Like, I genuinely don't care. It's not my fucking business. I fundamentally don't care if you smoke weed or sell weed. As long as you are not smoking weed while driving at 120 miles an hour, I really genuinely don't care. It's just fundamentally, like, it's not my business if you smoke weed. And, like, the idea of people still getting arrested for it just seems so ridiculous. Not paying public transportation fare, I'm like, Again, marijuana misdemeanors, do not give a fuck. Not paying public transportation fare, listen, if you don't live in New York City, you don't get how the MTA fucking rips you off every day. You give them $2, you get $2.75 or $2.50. I don't know. I used an unlimited Metro card from 2011 onwards, so I honestly don't even know what it costs without the unlimited to get there. Neither of the above. Neither of the above. Yeah, I would say neither of the above. Well, like, the MTA rips you off on a regular basis. Once you have waited in between subway stops or like where you literally can't get out for an hour because of issues with the rail, or you get on there and like the train that you thought was going to work, they just announce after 40 minutes is not coming. Trust me, fuck the MTA, fuck them in the ass hard. Again, like, so I don't really give a shit about this. Trespassing? Nah, fuck that. Like, prosecute fucking trespassing. Prosecute trespassing. That's bullshit. I'm glad you treat your employees with respect. I wouldn't go that far. I don't say I treat them with respect. I think I wouldn't say that. You're going a little too far there. I provide them with. I provide the best people that I find with enough compensation that I'm satisfied that they will not go elsewhere. But I wouldn't give myself that much credit. And resisting arrest, yeah, like again, this is going to result in people just thinking I can punch a cop while they're arresting me and try to get away and nothing bad will happen to me. Obstructing governmental administration, what does that mean? I mean, honestly, this means that like half of the people that I've been on the phone with the Department of Consumer Affairs would be getting prosecuted. Like, what does obstructing governmental administration mean? Because again, the average person that works for the New York City government is obstructing governmental administration. So I mean, again, from this description here, among the crimes, now here it's CNN says among the crimes he said he would not prosecute. This is not a list of all of them. This is not a list. So this tells me over here that this is not a list of all of them. So maybe CNN is just listing the crimes that that seem like you shouldn't be in jail for. So this is why we click multiple results on Google. So let's take a look at Pix 11. I don't know. One policy outlined crimes that would not seek a carceral sentence. Okay, so the first thing I got to do, because I'm an idiot, what the fuck is a carceral sentence? You're using... Okay, suggesting jail or... Okay, so this is bullshit. So here's the thing. This is the second time this has happened. In the CNN article, there was a word that got used that was a little confusing. Why are you using the word carceral sentence? Just say you're not going to put them in prison. So they are not going to seek a carceral sentence. What that means is that you're not going to go to prison. So one policy outlined crimes the DA's office would not for cases other than homicide or serious felonies. Okay, define serious felony. Serious felonies like domestic violence, some sex crimes, public corruption, and major economic crimes would still have jail time as a possible sentence. I'd honestly like to just read the fucking policy. I don't want to read CNN's interpretation. Because again, CNN's is saying among the crimes. Okay, growing up in Harlem in the 80s, I saw every side of the criminal justice system from a young age. Before I was 21 years old, I had a gun pointed at me 6 times, 3 by police officers, and 3 by people who were not police officers. I had a knife to my neck, a semi-automatic gun to my head, a homicide victim on my doorstep. In my adult life, I have posted bail for family. Please have a cookie. I can't eat a cookie, too many carbs. Last year, during a stretch of multiple shootings within 3 blocks of my home, I had perhaps the most sobering experience of my life, seeing through the eyes of my children the aftermath of a shooting directly in front of my home. Our home, as we walked together past yellow crime scene tape, seemingly countless shell casings and a gun just to get home. In large part because of these experiences, I have dedicated my career to the inextricably linked goals of safety and fairness. This memo sets out charging, bail, plea, and sentencing policies that will advance both goals. Data and my personal experiences show that reserving incarceration for matters involving significant harm will make us safer. These policies are premised on several key principles. Invest more in diversion and alternatives to incarceration. I don't know, sounds... I can't tell you why my gut I say but there's nothing bad yet. Well-designed initiatives that support and stabilize people, particularly individuals in crisis and youth, can conserve resources, reduce reoffending, and diminish the collateral harms of criminal prosecution. All right? Particularly given the ongoing crisis at Rikers, we must reserve pretrial detention for very serious cases. The data show the overwhelming majority of these released pretrial do not commit a violent crime while at liberty. I don't know about your data, man. Studies show that... How'd you get that data? Studies show that even 3 days in jail can lead to a loss of housing, employment, and strain on family connections, and increase the likelihood of failure to appear in court. Understandable. Again, if you're in prison, your employer will probably find a replacement for you. Studies also indicate that incarceration in and of itself can create public safety risks. I don't know about that. Okay, again, I could read this stuff. I'm barely gonna have time to read this thing, much less the study, but I'll bookmark this. Focus on accountability, not sentence length. Research is clear that after a certain length, longer sentences do not deter a crime or result in greater communal safety. Community safety. Further, because survivors and victims of crime often want more than the binary choice between incarceration and no incarceration, we'll expand our use of restorative justice programming. Look, I don't know what this word means, and again, I have to read a citation to figure it out. Restorative justice programming sounds weird. Limit youth in adult court. Research shows that brain development continues up to age 25. Youth are physiologically subject to more impulsive behavior and are still capable of growth and maturization. Prosecuting youth in our adult criminal court system can lead to recidivism, making neighborhoods less safe. I imagine prosecuting youth in an adult criminal court would lead to them being in prison for long periods of time. But again, like when they say that your brain doesn't really finish maturing until, a later age, I get it. But again, like I know a lot of people from high school. I know people from high school that were just kind of sociopaths that did a lot of fucked up shit. And, I catch up with them. And in my late 20s or early 30s, they change a little bit. Again, all sorts of people change. But the people that were genuinely fucked up in the head, like the people that actually enjoyed the suffering of others to the point where they would just punch a woman on the street, I haven't noticed a lot of change from the age of 16 or 30. I imagine that that's probably the wrong thing to say, but like some people are just fucked, and I just don't see it changing from the age of 16 to 25. Your brain changes. It does. The way that you deal with, the way that you express your impulsive thoughts does change. But there are some things where it's just, I feel like I'm not jiving with this guy, but again, I don't see anything here that leads to we're not prosecuting you unless you murder people yet. I'm not to that part yet, because that's been showing up in my YouTube comments a lot, and I don't see anything that serious. Actively support those reentering. Supporting those returning from incarceration reduces recidivism and thereby makes communities safer. We will scale up support for our services for those reentering and participate. Thank you, Cassidy, for the sweet mercy. Participate substantively in the parole process with a presumption in favor of release. Please note that a number of the policies set forth below create presumptions requiring supervisory approval and or writing to overcome these policy changes, blah, 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 blah. Okay, what do we have? Let's get to the fun shit. Charging. The office will not prosecute the following charges unless it's part of an accusatory instrument containing at least one felony. Marijuana, again, don't give a fuck. Unapologetic about it. I don't fucking care. Prosecuting people for marijuana misdemeanors is a fucking waste of time and money and effort and everything. I don't give a shit what you smoke in your house. The act of refusing to pay the fare in public transportation, don't give a fuck. If anything, prosecute the people that run the fucking MTA first, not us for not paying for the shit service. Trespass PL under the trespass is a family offense. Okay. Trespass, I mean, if you're trespassing, come on, man. Like, if you're trespassing, I'm not with it. So this, prosecute people who are trespassing. Aggravated unlicensed operation. Note that any vehicular collision. Okay, what is aggravated unlicensed operation? I actually don't know what that is because I'm an ignorant fool. So let's see. Aggravated unlicensed operation of a motor vehicle is a traffic-related offense, which in simple terms means you were caught by the police driving knowingly with revoked. Okay, I know a lot of people doing that. So essentially, there's a lot of people that drive like crazy, and then they get their license taken away because they drive like crazy. And you see them in my streams. You'll see people that just like don't use a turn signal and just zoom. And there's a lot of dangerous driving. And there's this one dude that actually wound up hitting a car that then hit a child that killed him. And I don't know if I'm with that. Yeah, I mean, again, if you drive a car without a license because your license was taken away from you, and then you wind up driving in a dangerous manner, I don't know. I'm not against you being put in prison for that. But maybe I'm being over mean. But I would never drive a car without a license. It's just like I'm just not going to do that. This policy addresses only criminalization of a failure to pay fines. It does not address the criminalization of dangerous driving. Okay, never mind. I take back what I just said there. Okay, it addresses the inability to pay and does not address the criminalization of dangerous driving. Okay, you know what? I just take back what I said. I didn't read the entire thing, and I got ahead of myself, so my bad. Any violation, traffic infraction, or other non-criminal offense not accompanied by a misdemeanor. Okay, so they're probably talking about like red light cameras and other shit. Putting people in prison over red light cameras is like a fucking waste of time. Resisting arrest, except for the act of resisting arrest for any crime not included in this list. Yeah, I'm not a fan of that, because again, this is going to result in people thinking like, I'm going to run from the cops, I'm going to punch the cops, blah blah blah. Like again, if somebody's about to arrest you and you know that it's not going to be added to your list of things to be prosecuted if you run away, I don't know. I'm not for that. Alexander Rose for £2. Thank you. Thank you very much. Obstructing governmental administration in the second degree. Okay, I'm not for this because I believe that the people that run the Department of Consumer Affairs, who routinely obstruct governmental administration by not answering my questions on how their shit works, I would love to see them behind bars. But anyway, I'm half kidding here because I don't actually know what that means. H, prostitution. I don't give a shit if you hire a prostitute. It's just fundamentally not interested. Again, if you want to pay somebody to suck your dick, or I don't care. If you want to pay someone to bang you in the ass, like, by all means, that's not really my business, and I don't particularly give a shit. And I think it's a waste of my taxpayer dollars to bother prosecuting you for it. Now, if you were talking about some underage shit or a pimp that's trying to pimp out a 13-year-old, by all means, go into that. But if you're talking about like some 25-year-old hoe and somebody that wants to pay her for a fun time, like that's really just not my business. Outdated offenses such as obscenity and adultery. What? Okay. You can go to prison for fucking... that's interesting. You go to prison for fucking somebody else? I did not know that. But yeah, okay. I'm with the DA over here. Fuck prosecuting people for that. I mean, if you were able to get prosecuted for obscenity, then, I mean, I'd be in prison for this stream. Next. Misdemeanor charges for which a desk appearance ticket. What about trespassing the Capitol? I don't think that that's under the New York DA. So this is the New York DA. Wouldn't that be a federal crime? I don't know. I mean, if the people that broke in, feel free to put them in prison. Like, I don't have a problem with them being put in prison. I have a basic sense of personal responsibility. And if you decide to run into the Capitol building and like take a shit on Nancy Pelosi's desk or whatever, like, by all means, enjoy the selfie. It's just, if you go to prison afterwards, I really don't feel bad for you. And I would lean on the side of go to prison. Yeah, go straight to jail. Go straight to jail, you prick. Consistent with past policies, those arrested and offered diversion will be permitted to consult with an attorney. Okay, I don't... let's see. Misdemeanor charge for which a desk appearance ticket is required by law. I don't know what those are. Cases for which a desk appearance ticket is issued but not required by law to be issued will be offered to the diversion option defined herein unless the allegations include sex offenses, assault, menacing, or allegation of any harm or threat. Okay, so he's pretty much saying if you try to punch somebody, if you hit somebody, if you threaten somebody, you're not going to be excluded from prosecution. Okay, so again, I'm a fan of it. People died in the Capitol invasion. If I don't know what you want from me, man. I said that they should go to prison. I mean, do you want me to say that they should be like sent to North Korea and like be hung by their balls? Like, what answer are you fishing for? Favorite YouTube channel, if you don't mind sharing. Eli the Computer Guy, circa 2010. I love me some archive.org Eli the Computer Guy. Preemptively offers rare. ADAs should use their judgment and experience to evaluate the person arrested and identify people who suffer from mental illness, unhoused, who commit crimes of poverty, or who suffer from substance use disorders. Immediately identify such cases to an ECAB supervisor. Charges should be brought consistent with the goal of providing services to such individuals, and leverage plea negotiations should not be a factor in this decision. So this over here, I think this is really up to the person that's actually going to be doing it. Like, would Eugene be a crime of poverty? Like, again, like this guy, he got a divorce. In my opinion, he burned his own fucking house down for the insurance money, or to get out of the state taking it, or to get out of the state taking it, and then he ripped me off for $20,000 or $30,000. Like, should he, if I were actually able to pursue that, should he not be prosecuted for fraud because it was a quote crime of poverty? Because there's different types of poverty. There's poverty of your own making because you're a piece of shit, and there's poverty just because you got a shit hand in life. Like, there are people like Eugene out there that are poor because they were pieces of shit. They made many, 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 many decisions that are very well documented in court that led to him being poor. He fucked people over. He defrauded people repeatedly when he had many opportunities to make money, and he's poor. I don't really care that you're poor at that point. You did it to yourself. But then there are people that are poor because they lost their job, they had medical debt that they couldn't file. I don't know, they had medical debt, they had student loan debt, their house burned down, and now they're homeless, and now they stole a loaf of bread from the store kind of thing. So again, use your judgment and experience. Use your judgment and experience. I understand that. That makes sense to me. I just want to know whose judgment. The following offenses shall be charged as follows. An act that could be charged under PL 160.15 or 160.10 or 160.05 that occurs in a commercial setting should be charged under PL 155. What the Okay, so we're at the point where we're not talking English anymore. Okay, an act that could be charged under PL 160.15. Yeah, this is gonna... Now, see, this is probably why... Okay, here we go. The fun section. Robbery in the first degree. Okay, I think the reason we're talking... Firstly, this is why people get their news from second-hand or third-hand sources rather than primary sources, because the primary source requires your brain to decode. But the second is, when we start to talk about the spicy stuff, that's where we start talking in code. Okay, so an act that can be charged under PL 160.15 or 160.10. Oh, we're gonna Google each one of these fucking things, because now I can tell, the spicy shit is gonna be said in numbers. Robbery in the second degree. Okay, robbery in the second degree. Bada bing. Next. Should be charged under profit and loss 155.25 if the force of threat or force displaying a dangerous instrument or dangerous behavior but does not create a genuine... Oh, fuck off! If the force or threat of force of displaying a dangerous instrument or similar behavior but does not create a risk of physical harm. Fuck you! Okay, like, before I even Google this, even before I Google this, I want to say fuck you. So, the threat of force consists of displaying a dangerous instrument, like a gun, but does not create a risk of physical harm. If I point a gun at you, how is that not a genuine risk of physical harm? I know what they're talking about here. I know. Okay, I got it. Before I even Google this. There was a case a while ago. There are these cases from time to time. Now, I can tell you how they determine this. Check this out. So there are cases where somebody will walk into a bodega with a gun and say, give me the money in the register. But there's no bullets in the gun. But the person behind the register doesn't fucking know that because he doesn't know if there's bullets in the gun. So he just takes the register and gives it to the person who runs away. So I think, and again, I could be wrong. I still got to Google what PL 155.25 means. I imagine here what they're saying is if you displayed a gun but there's no bullets in it. This seems like the intellectualized, collegiate way of claiming that you weren't actually in danger simply because the person who robbed you with a gun that didn't have bullets in it. I've heard this happen. I have had a story of this happening at least 3 times. And there was one case about 7 years ago in this area where somebody wound up getting shot by the cops, and there were complaints because the gun that the kid had no bullets in it. But how the fuck is the cop supposed to know that? But that's the only thing I can imagine that this covers. But let's Google this, because again, I'm getting carried ahead of myself. Again, you can see, my neck is turning red. I'm getting aggravated before I even Google it. So this is not what I should be doing. So let's see. What is PL 155.25? 155.25, this is going to get charged under this. So it gets charged as petty larceny. So a person is guilty of petty larceny when he steals property. Petty larceny is a Class A misdemeanor. Wait a second. Wait. Okay. So 160.15, so that's a misdemeanor now. So PL, okay, let me see. Was this a misdemeanor before? That's what I want to know. Because again, this is why you read the primary sources. I'm not reading CNN or Fox's interpretation. Fuck that. That'll literally rot my brain. Read it again. It's not in a threatening manner, meaning like lifting it up and not pointing at anybody. Okay, but what does that mean? If the force or threat of force consists of displaying a dangerous instrument or similar behavior but does not create a risk of genuine harm. There is a 71-year-old veteran that's still in jail from January 6th. He took nothing, broke no laws, and is unarmed. Where is his speedy trial? Welcome to America? Again, if you break into a building, again, it's a question of trespass. Like if somebody breaks into your house, or, he takes nothing and breaks nothing and was unarmed, do you want that person to go to jail? Would you want that person to go to jail? Again, they broke in your house. Oh, dude, again, if we're going into this thing somebody let them in. Listen, you're not supposed to be breaking into certain parts of the fucking Capitol. That. Again, when you're doing something that's probably wrong. That you're probably not supposed to fucking be there. That you're probably not supposed to be trespassing in there. Even if somebody lets you're not supposed to be there. Just be real. Again, I want to see people held to account. Whether it is somebody that trespassed in the Capitol, whether it is somebody that was breaking store windows during the George Floyd riots, whether it is somebody that is breaking into stores or breaking windows and rioting and shit, I don't give a fuck who it is. If you're causing random crap like that, again, just know. When you're doing something wrong. In your heart of hearts, But continuing on to this, because now we're getting into a January 6th fest here. Now, I know some people are going to say, well, what is a dangerous instrument? There are different definitions you could have for dangerous instrument. Over here, you have penal law defines dangerous instrument as any instrument, article, or substance which, under the circumstances in which it is used, is readily capable of causing death or other serious physical injury. This standard requires some unpacking. Clearly, a large kitchen knife is capable of causing death or serious physical injury if it is used against another person. On the other end of the spectrum, it might be possible to seriously injure someone with a paperclip, but is that readily capable of causing a serious injury? The appellate court recently addressed such a borderline case in the People v. Zeman 2017. In Zeman, the defendant was convicted after trial of assault in the second degree based in part on use of a broom in the assault on the victim. While it is clear from the definition of dangerous instrument that the manner in which an item is used and the context in which it is used is critically important to determine whether or not the item can be considered a dangerous instrument, it is equally clear that the item must meet some baseline of being something that is reasonable, capable of actually causing serious physical injury. You might imagine that a paperclip could do a lot more damage than a broom in certain circumstances. In any event, the court in Zeman held that a broom does indeed meet this baseline standard and can be considered a dangerous instrument in the right circumstances, elevating what would otherwise be a misdemeanor charge to a violent felony punishable by state prison time. So there is some sort of subjective nature to this that the courts have to decide. But what is more interesting to me is, again, two things. A, when you read robbery in the first degree, it includes using or threatening the immediate use of a dangerous instrument. It includes being armed with a deadly weapon. But most importantly over here is the wiggle room given in this statute when you read 6A. It says if the force or threat of force consists of displaying a dangerous instrument or similar behavior. So even if you were to say that my example is incorrect because you can argue that a gun is not a dangerous instrument, or similar behavior. So this or similar behavior gives you a lot of wiggle room to be able to take a first-degree felony, such as robbery in the first degree, and bring it down to petty larceny, which is a misdemeanor, which is going to raise the eyebrows of a lot of people, which is one of the reasons I imagine that rather than this be in plain English, we're now talking in PL and N symbol 160.15, 160.10, 155.25, and this is also one of the reasons that I imagine in the CNN article that we have over here that they did not bring this up. Either A, because they are biased, or B, because this would actually have required a basic Google search to figure out what all these different numbers and letters mean over here. I mean, what I'm reading is, if the force of threat or force consists of displaying an instrument but does not create a risk of physical harm. If I point a gun at you, but it's not loaded, and I checked it, and I didn't Alec Baldwin, I actually checked it, and it's not loaded. I'm not no Alec Baldwin, and I know it's not loaded. Is that not a risk of genuine harm? There is zero risk of me harming you if I point a gun at you that I have double-checked and ensured is not loaded. There's no way I could harm you with a gun that's not loaded. So again, the reason that I'm doing this is because I've seen these cases covered before. Clearly you haven't seen someone using a gun as a hammer. No, I've seen that before. It's just, that doesn't change what we're talking about here. We're talking about a threat of force, about displaying a dangerous instrument, but not creating a risk of harm. And I could see that being used if somebody has a gun, but they just do this. And they never, well, what if they just do this? What if they just go to their holster, right? Oh, hey, how about this? What if they never even touch their holster, but they just do this, right? It's like they start lifting their shirt to reveal it there. Is there a threat? I don't know. But it's just, this seems real. And again, 160, I just want to see what this is. So they would be classifying this as a misdemeanor, but PL 160.15, what is that? So robbery in the first degree is now a misdemeanor? So, okay, so here's the rub here. So check this out. Section 160.15, robbery in the first degree, which is a fucking felony, and he is saying that you are going to charge this as petty larceny, which is a Class A misdemeanor. So this is saying that if you have a weapon or whatever, but that weapon itself is not creating a genuine risk of physical harm, which, I don't know, let's say if you have a dull knife or a gun with no bullets in it, that robbery in the first degree is now being downgraded from a Class B felony to a Class A misdemeanor. And again, I'm not reading CNN, because when I read CNN, they don't talk about any of this. Again, when I read CNN, they were just talking about marijuana and prostitutes. And I haven't read Fox yet, but I guarantee if I read Fox, it's going to be crazy in the other direction. This is why I actually wanted to read this. Again, it takes more work and effort, but it is worthwhile. But here's why I think this is so important. Here's what I get out of reading this primary source. And here's why this is important. So when you read the primary source, when they're talking about the things that we can all agree on, like marijuana, like, okay, who cares about that? Prostitution, who cares about that? Adultery. When we're talking about the items that even right-wingers and left-wingers alike will agree on, they use English. When they talk about the stuff that they know, most average ordinary people are going to read and go, wait a second, what the fuck? You mean felony robbery is now just going to be a misdemeanor? They start talking in fucking algebra. See this? Do you notice that? Do you notice that pattern on this? Again, when we're talking about the things that we're not going to be charging or, as seriously or putting people in prison for, when we're talking about the items that most people in America are going to agree on, marijuana misdemeanors, they say what it is. Not paying fare, they say what it is. A traffic infraction, they say what it is. Not penalizing you for obscenity or adultery, they say what it is. But once we get to the point where it's actually controversial, that's where it doesn't say what it is, and we start magically talking in algebra. So again, 6A, an act that could be charged under 160.15, which is robbery in the first degree, which is a Class B felony, is now going to be charged as petty larceny, 155.25. And again, I'm just reading this directly from the document, and I'm going to post all these links into my chat so that you can read along as well, because you should not believe me, because I'm just a random dude sitting in his chair. Again, don't believe me, believe this. Believe what you read. So this is where it starts to lose my trust. Because if there was nothing, if you weren't trying to hide the ball, you would just say what that is rather than speaking in algebra. Let's keep reading. The possession of a non-firearm weapon under Penal Law 26502 shall not be charged unless as a lesser included offense, and 26501 shall be charged instead. Okay, so let's see what these two are, because again, we're talking in fucking algebra again. So 26502, we'll just do this. Section. Yeah, I'm just learning this as I go, just to be clear. I don't know jack shit about the law. I am literally learning this along with you. I'm a MacBook repairman. And 26501. So what the fuck does this should mean? Okay, so what is this? What do we have here? So 26502, criminal possession of a weapon in the third degree. That is a Class D felony. That will be charged as criminal possession of a weapon in the fourth degree. Class A misdemeanor. Okay, so possession of a gun, of a weapon. So possession of certain types of weapons are now going from felony to misdemeanor. I don't think that your average person who is right-wing or watches Fox News is going to be particularly mad at that, because I think most people who are more right-wing are going to believe that it's wrong that you not be able to possess a weapon in the first place. So I'm not really mad at that. Again, I could read this entire thing. Yes, it is Andy. I could read this whole thing, which is many pages, but at the end of the day, that really doesn't make me that mad, so I don't think that that's something that's worth reading through the entire thing. I could be wrong, but... Residential burglaries, an act involving theft of property from a storage area or other portion of a dwelling that is not accessible to a living area that could be charged under PL 140.25 should only be charged under 140.20 and not under 140.30 or 140.25. Okay, again, we're getting into the fucking land of algebra here, so let's just go through this. What would you suggest for a complete beginner like myself? Get started. Watch videos, get started, get stuff, and practice. Go, go, go. Don't wait. No waiting. Go, go, go. Okay, so 140.25. So burglary, let's see. Burglary in the second degree. Person is guilty of burglary in the second degree when he knowingly enters an unlawful building with intent to commit a crime and affecting entry in the building or immediately fight, armed with explosive or deadly weapon, causes injury, threatens immediate use of this, Class C felony. Burglary in the third degree, when he knowingly enters a building with intent to commit a crime, Class D. Okay, so the difference appears to be whether you have a weapon. Okay, so it looks like if you're committing a burglary with a deadly weapon, it's now going to be charged as if you did not have a weapon. Okay, and not under 140.230. So burglary is now, again, you're going to be prosecuted with kid gloves if you do burglary and also if you do robbery. This fucking sucks. I'm not for this. Okay, let's see. Oh, yeah, you also... Okay, so if you were doing burglary in the third degree, now you can get charges in the fourth degree rather than the first degree. Okay, so far here, 6 really seems to be where it gets spicy. The rest of this document, again, I just don't give a fuck about. So A says A over here, if you're committing a robbery, that robbery with a deadly weapon can go from being a felony to a misdemeanor. B, don't give a shit about, because I believe in the Second Amendment. I personally I don't believe that most of this shit should even be shit you're getting charged for. I don't want to be a hypocrite there. C, residential burglaries. Okay, you're going to get charged with some kid gloves there. And next, commercial burglaries. This is obviously where I got some bias, because I own a fucking business in this shithole. Commercial burglaries, an act involving theft of property from a commercial establishment, could be charged under PL 142.5, because establishment is technically part of a larger structure, shall only be charged under 140.20. Now, he's not saying instead of, so he's not saying what that would be charged under right now, so I don't really have knowledge of what this is being charged as right now. Let's see. New York Penal, this... Did I just say New York Penal? I said penal. I'm such a fucking child. Okay, so shall be charged, could be charged under this, shall only be charged under 140.25. So what's 140.25 versus 140.20? 140.25 is burglary in the second degree. Will get charged as burglary in the third degree. Okay, so again, this is just kid gloves. This is kid gloves for burglary. Is what I get. Drug cases. If there's a reasonable view of the evidence that they're arrested for this. Okay, again, I don't give a fuck about this. I just want to be clear with because if I don't care about drug cases. Like, I fundamentally don't care about them. So if they're talking about a drug case, I'm not even going to look up the different penal codes, because, as I said, my own code of moral and ethics, I fundamentally don't care if you're doing drugs. It's not of interest to me unless you're driving. If you're driving or operating heavy machinery that affects me, then I care. But otherwise, I really don't care. Pretrial detention. There is a presumption of pretrial non-incarceration for every case except those with charges of homicide or the death of a victim, a Class B violent felony in which weapon or dangerous instrument causes serious physical injury, sex offenses in Article 130, domestic violence, blah, including any attempt to commit any such offense. For any charge of attempt to cause serious physical injury, ADAs must obtain the approval of an ECAB supervisor. What the fuck is an ECAB supervisor? Okay. I don't even know what ECAB is. I know ACAB is all caps are bad. Is ECAB like elderly cops are bad? What is ECAB? What is ECAB? Early Case Assessment Bureau. Early Case Assessment Bureau. What the fuck is that? What is this? I'm clueless. Let's learn. Screens all arrests that occur in Brooklyn, determining whether a prosecution will be declined or will go forward if the latter, or what charges will be brought. ECAB office staff members interview police officers, and in some instances victims and witnesses. The Bureau drafts the charging document upon which the defendant will be initially arraigned. Okay. Let's see. A Class B violent felony in which a deadly weapon or dangerous instrument causes serious physical injury. Let's see. For every case except those with the... Okay. Okay, so for cases where you're not causing injury, you're not being a sex offender, ask an ECAB supervisor if you're going to seek that they be put in jail. That's... I don't know. That doesn't seem like the craziest thing in the world. There is a presumption of pretrial non-incarceration. I don't know. That's. I'm not going to jump down the throat for that. Now, I don't know what the ECAB supervisor process is like. I don't know if they're just going to rubber stamp every single one of them to just say, yeah, leave them on their own recognizance. That's always a possibility, but I don't know enough about the system to know if this is something to be worth getting angry over. After submitting the application for pretrial detention form to their ECAB supervisor, where release is recommended, the following rules apply. The office will consent to the release on recognizance whenever release is recommended by the CJA risk assessment or blah. What this really kind of sounds like an ECAB supervisor is going to be able to say whether or not somebody who commits a crime is going to go to jail prior to having their date in court. I think they're doing that to keep people out of Rikers. And again, this is whether or not that's a bad thing really is going to be up to whether or not the ECAB supervisor winds up looking at each case and making a decision that the public agrees with, or if that's just a rubber stamp way to keep them out of jail. And again, I don't know enough about the legal system, the justice system, or the policing system to be able to answer that. And so I just don't really have much of an answer there. For cases where there is no presumption of non-incarceration, the office should carefully consider all known facts. Special consideration should be given to any request for pretrial detention for the following individuals who face unique hardships, such as individuals with health conditions that could suffer serious harm or death if incarcerated. Yeah, I guess. I guess it depends on what you did. Like, again, if you tried to fucking stab my dad, but, you have a health condition, I don't really give a shit if you die in prison. But if you have, if you're just somebody who took some bread from the store to feed your family and you have COVID, I get it, let him out. I guess it really depends. I'm not necessarily mad at this at face value. That's not worth being mad at face value. When requesting bail, ADAs must request a partially or unsecured bond in the same amount as the cash bail request. If the defense counsel requests, ADAs must request a partially or unsecured bond in the same amount as the cash bail request. I don't think that's not worth me getting mad at. If defense counsel requests, ADAs working in the arraignment part shall inform defense counsel prior to their client's arraignment of the officer's bail request and any plea offer. For those individuals whose conditions, particularly their physical and mental health, change during incarceration, the Pathways to Public Safety Bureau, what the fuck is that? How many bureaus are we paying for? Pathways to Public Safety Bureau will review and consent to a change in bail or release conditions if necessary. There are so many, I'm learning, there are so many different departments in New York City and state. Wow, this is crazy. If individuals miss court dates, ADAs shall contact defense attorneys to request them to provide the reason for the violation or failure to appear in court. If individuals miss court dates, ADAs shall contact defense attorneys to request them to provide the reason for the violation or failure to appear in court. If the person fails to appear, but there is no evidence that the person intentionally attempted to flee from law enforcement, such as evading police or giving a police officer an alias, then recommend release upon the original conditions. What are you talking about? If you commit a crime and you get a court date, you show up or they put you in jail. ADA shall contact defense attorneys to request them to provide the reason for the violation or failure to provide. Are you serious? That's literally like, my defense attorney ate my homework, so I didn't go to court that day. Next. Okay. If there is an allegation that an individual has violated a condition of release, ADA shall contact the defense attorney to determine whether the violation of the condition is related to circumstances such as health issues, transportation, or child care issues. If there is clear evidence that the person willfully violated a condition of release, ask for the next least restrictive condition to ensure that they fulfill the conditions of the release. Supervisory approval is required for any deviation from this policy. So I'm going to claim that a customer coughed on me. That's why I couldn't go to court. I got COVID. Oh, man. There's a lot of COVID. It's not hard to get New York City and COVID nowadays. I genuinely appreciate the alcohol-free stream. Thank you, Mario. I hope you're doing well. Thank you for the €5. In appropriate cases, the office will consent to the excusing of the defendant from having to attend routine court appearances. What does that mean? The office will consent to excusing the defendant having to attend routine court appearances. If that, I don't know why you'd want that. I don't know why you'd want that because, I imagine you would want the jury to hear your side of the story. I imagine if you don't show up, they're going to assume you're guilty. That's dispositions. The office will not seek a carceral sentence. To be clear, again, one of the things that I pointed out at the beginning of this, they start using either algebra or advanced vocabulary the moment that they get to something that's spicy. Like, again, when they're saying, we're not going to prosecute prostitution, we're not going to prosecute adultery, they're very specific. But when they get to something else, like, we're going to prosecute a felony robbery or burglary as a misdemeanor, they start talking in 160.15 will now be prosecuted as 155.10 and shit like that. Over here, when seeking a carceral sentence apparently means you're in fucking jail. So just to be clear about this, when they say a carceral sentence, which is a word that I never heard of until I started reading this, that means relating to or suggesting a jail or prison. So instead of carceral sentence, let's just say that assumes jail or prison. For a determinate sentence, the office will request a maximum of 20 years. Why? What is an exceptional circumstance? Like, again, let's say that Cinevision comes back from Hawaii and then somebody kills Cinevision. I would want them to get more than 20 years. Like, what is considered exceptional? Who defines exceptional? For an indeterminate sentence, other than one with a maximum of life, The office will request no more than a maximum of 20 years. Again, what is an exceptional circumstance? I want to know what this Weasley vocabulary means. What does this Weasley vocabulary mean? The office shall not seek a sentence of life without parole. That's exactly what I'd want if somebody kills my Cinevision. In exceptionally serious cases, such as homicides, where lengthy periods of incarceration are justified, ADA shall consider the use of restorative justice. What the fuck does that mean? As a mitigating factor in determining the length of sentences, only when victims or their loved ones consent. What the fuck is restorative justice? Like, why, what the... Okay, let's figure out what these terms are. Restorative justice. Restorative justice repairs the harm caused by crime in exceptionally serious cases such as homicides. Okay, so here's the thing that makes no sense. You understand how their very fucking language makes no sense. Restorative justice repairs the harm caused by crime. Yet it says, such as homicide. So if you kill my girlfriend, how do you fix that? How the fuck are you gonna fix that? This is so fucking stupid. Like, what am I missing? What am I missing here? So they're again, if they said excluding homicide, I'd get it. So for instance, let's say you destroy the front of my store, but then instead of you going to prison, they say you are going to stay in this fucking store until you fix everything of Lewis's that you broke. See, I'm for that. Listen, instead of you going to prison, you're going to go there every fucking day and you are going to fix what you broke. But they're talking about homicide. Homicide. How do you fix that? What is restorative? Like, these words make no... Even if the word it's... Okay, now I understand the concept of restorative justice. Restorative justice repairs the harm caused by a crime. When victims, offenders, and community members meet to decide how to do that, the results can be transformational. You killed someone! You don't fix that! You can't bring them back! If you could bring back people, we would have had no arguments about COVID restrictions over the past year, because when they die, you would restore them by bringing them back. Like, oh my God. What the? Okay, we'll read another definition. Maybe that definition is not the right definition of restorative justice. Let's get another definition. Wikipedia. Restorative justice is an approach to justice in which one of the responses to a crime is to organize a meeting between the victim and the offender. That's not going to go well if the offender killed my fucking girlfriend. Sometimes with representatives of the wider community. The goal is for them to share their experience of what happened, to discuss who was harmed by the crime and how, and to create a consensus for what the offender can do to repair the harm from the offense. Nothing! If you kill someone that I love, there is nothing you can do besides fucking go to prison, rot, or let me choke you to death. If you stab my dad, who is 72 years old and has had 7 surgeries outside the grocery store so that you could steal the $3 he has in his wallet, there is nothing you can do other than let me kill you with my own 2 hands that will make me feel better. And even that's not going to work because I'll feel better for 15 seconds and then I'll feel like shit after I do it. It's like... This is horseshit. This is so fucking... Like, just listen to the words. In exceptionally serious cases... Such, again, if this said excluding homicide, I get it. Such as homicides, where lengthy periods of incarceration are justified, ADA should consider the use of restorative justice as a mitigating factor in determining the length of the sentence. Okay, I didn't read the entire sentence because I was raging. Only when victims or their loved ones consent. Okay, to be clear, I ran on that entire rant before reading the end of the sentence because I'm a fucking idiot. Only when the victims or their loved ones consent. So if I consent, listen, if I consent to allow, and you killed my dad, but I say, you know what, fine, fuck it. My dad was a prick on my last phone call anyway. I'm glad you did it. Give him only 2 years. It's only if I consent. But if I don't consent and I say, fuck it, you deserve 25 to life, then they still get 25 to life. So I didn't read the whole thing. That's a horrible hypothetical. I mean, we're talking about homicide here. Can you give me an example of where that's not going to be, we're going to have happy hypotheticals? Again, to be clear, it says only when victims or their loved ones consent. So I would have to consent to this happening. Meh. Okay, so what do you all think of that? So the person could kill someone that you care about and love, but they can only get a reduced sentence if you consent to them getting a reduced sentence. What are your thoughts there? How do you prove they're a loved one? I don't know. Make up a fake card or something?
Sweet mercy.
New York City public school at its best. Yeah, I didn't finish the sentence. No justice for the dead person if their family hates them. That's a good point. Yeah, that's actually a really good point, because I know people in my family that would be more than happy that if I, I know people in my family that would be like, yeah, just let them out if I wound up getting murdered. Consenting to a murderer being let out means they will harm other people. Kind of, I'm on your side there. The dead person doesn't forgive.
Oh, sweet mercy.
You killed my father, you can restore the situation by becoming my new father. That's kind of weird. Wouldn't consent encourage intimidation tactics? Good point. I wasn't thinking of that, Sidedark. I was not thinking of that. So what if a gang member kills somebody's family, or kills somebody's family member, but then other members of the gang say, we're going to come after you if you don't, get in on this whole restorative justice shit. You talk to them and tell them that you forgive him so that he gets out in a year or 5 years or something like that. I'm not necessarily comfortable with my family members having the power to give consent on behalf of my dead ass. Yeah, and especially considering some certain members of my fucking family, I wouldn't trust that. Don't kill someone if you're not willing to die. The golden rule, treat others as you want to be treated. Okay, anyway, continuing on to the next one. Restorative justice programming will be expanded significantly, including for violent felony cases in which the victim consents. This sounds a bit cuckish. Wait, so you can hire someone to kill your wife and consent for the killer to be released? Okay. Sonny, I know your divorce did not go the way that you wanted it to. No, Sonny. Stop. Sonny, you're going to give me COVID. No, Sonny. No, that's not how this works. Sonny, that's not a good way to get out of alimony. Oh, I shouldn't be laughing at that. Oh, man. Sonny voted for this fucking DA, didn't he? Oh, my God. Okay. Hi, Oreo. You a little hitman, Oreo? For any case in which a person violates the terms of a non-carceral sentence or pre-plea programming mandate, the office will seek a carceral alternative only as a matter of last resort. The office will take into account that research shows that relapses are a predictable part of the road to recovery for those struggling with substance abuse, and the office will reserve carceral recommendations for repeated violations of the terms of the mandate. Okay, there's no citation here, so I don't know how to interpret this. It seems like, again, the way that I can imagine this is relapses are a predictable part of the road to recovery for those struggling with substance abuse. So again, if they're saying they will take that into account if you're not supposed to smoke weed, but you smoke weed over and over again, fine. If they're saying because you do drugs, we are going to look the other way if you rob a deli, fuck that. But again, there's not really enough in there for me as a non-legal expert to understand what they're saying. Special procedures for cases involving juveniles and young adults. For adolescent offenders charged with offenses defined in Subdivision 1 of CPL 72223, office shall presumptively not file motions preventing removal to family court unless the charges are extremely serious and the young person does not demonstrate amenability for the services in family court. Okay, now, this is going to be something spicy because they are not using English, they are using algebra. So CPL 722.23, what does this mean? CPL, criminal procedure law, what is... proceedings against juvenile offender. Removal of adolescent offenders to family court. For adolescent offenders charged with offenses, not demonstrated amenability to the services available, an ADA may overcome the presumption by form to supervise at least 3 days prior to the hearing held, pursuant to 722.23a, and after such supervisor approves. I think they're talking about putting something in family court as opposed to charging you as an adult. So if you do fucked up shit when you're 16 and 17, being able to get lighter prison sentences. The officer shall consent to the removal of all juvenile offenders to family court pursuant to 722.22, permitting the court to make its own analysis of the statutory factors when required, unless consent is not statutorily justified. For the cases that are not removed to family court, Porio is pleading the fifth. Oh, Porio is cute. He's my cute little kitten. For the case not removed to family court, determinations as to the appropriate disposition will be based on the identifying and underlying needs and what services and supports can be provided to the person charged and their caretakers to address those needs, ultimately improving public safety. We will rely on community-based programs already in use in the youth parts, as well as adding restorative justice practices to accomplish these goals.
Sweet mercy.
For those cases not removed to family court, the office will consider removals to family court based on continuing behavior while cases are pending in criminal court and sealing of charges upon demonstration of the rehabilitation. For those cases involving adults under the age of 25, ADA should make an individualized determination of the appropriate outcome for each case. Blah. Okay, and this is an interesting one. So if you commit a misdemeanor and you are an illegal immigrant, they're going to avoid immigration consequences for misdemeanors. All felonies for which non-carceral outcomes are presumptive outcome. So this is an interesting thing, but here's where this becomes interesting. So it's talking about misdemeanors, but this memo makes it so that if you're committing robbery as a felony, that is now being charged as a misdemeanor. So you could commit what is currently considered to be felony robbery, and if you're an illegal immigrant, not even have immigration consequences because that's been moved down to a misdemeanor. Okay, I've read the entire thing at this point, and as an idiot who doesn't know anything about the law, ultimately, the spiciest part of this entire document, what I got out of it was really this section over here. 6A, B, C, and D. 6A through 6D is going over commercial burglaries, residential burglaries, and felony robberies being decreased to misdemeanors. And the second thing here that really seems to strike me as important is where it says that if this occurs in a commercial setting, it should be charged as a misdemeanor if the force of threat or force consists of displaying a dangerous instrument or similar behavior, but does not create a genuine risk of physical harm. And again, to me, the way I interpret this as a layperson who is not an attorney, not a lawyer reading this is, if I walk into a bodega and I'm about to rob the bodega and I say, give me all your money, and I do this and I raise up my shirt to show that I have a gun there, but that gun is not loaded, that if I were a defense attorney, what I would do is I would say, his gun, as you could see from the police, has no bullets in it. Therefore, there was no genuine risk of physical harm. Therefore, this should be a misdemeanor. And that's the spiciest part of this that I understand. This is I think all drugs should be legalized or criminalized up until the moment I see a tweaker dropping turds in the street in Seattle. Yeah, I hear you. Well, yeah, so that's my take on this. So, I read through the entire thing. Now, I'm kind of curious to see what other people are saying about this, because remember, I Googled this. Now, the CNN did not mention anything regarding, let's just see if CNN, how much can I trust this? So, does CNN mention the word burglary? I type Control F and I type burglary, it doesn't even show up. So, if you go to CNN, robbery, again, if I just type the word rob and I hit Control F, it's not there. Burglary, and the CNN article, literally, it's not here. Felony, it's not here. So the CNN article that I read that based on this memo does not tell me jack shit. And one of the things to notice about the CNN article is that it talks about marijuana, it talks about prostitution, but it doesn't talk about the things that I'm actually interested in, which are robbery, burglary, and, again, waving a gun around at people. So at this point, I'm glad I read the primary source document, because if I didn't read the primary source document, I would have thought something much different. Again, I read the CNN article at the beginning of this because, admittedly, I'm lazy and I didn't want to read the primary source. And I thought, oh yeah, this is just about adultery. This is about prostitution and marijuana. Who gives a shit about it? Because again, I fucking don't care if you want to sell weed. It's 2021. You literally cannot trust any news article. You always have to read the source document on gov.gov and make your own opinion. Unfortunately, that takes too long for most people to do. Yeah, and again, one of the things that I want to point out here that I think is really important, and I know I'm repeating myself at this point, but I'm repeating myself because I think it really is important, is that when they're going over the parts that are not controversial, such as marijuana misdemeanors, or going over the turnstile in the subway, or prostitution, or obscenity or adultery, they're willing to use normal language. But the moment they get to things that, in my opinion, your normal average everyday person would say, whoa, that's really controversial. You're taking robbery in the first degree and saying that it should be charged as petty larceny, that they're no longer using their words and they're using algebra. Now, again, I've had people saying to me that I read that in New York, they're not going to charge somebody if they commit a robbery or if they commit a felony. And obviously that's bullshit. He's not saying that. He's not saying don't charge them. He's saying charge them with something lower, which is better than what people are accusing the DA of, because I've read many YouTube comments at this point where people are saying the DA is asking that people not be charged at all if they commit a robbery or if they rob a store. That's obviously not true. They're going to be charged. But so I can't believe I'm fucking defending this DA, but it's just because people make things up. But he's charging them with something that's considerably less, which I fundamentally disagree with. So again, what I would suggest is read the source document, because I've gotten a lot of YouTube comments at this point that said they're not prosecuting robberies in New York City. They're not prosecuting felonies in New York City. I mean, that's not true. They are. It's just they're prosecuting them as lower statutes. So again, it's just one of those cases where both sides lie, and when one side lies about one thing, it's easier for you to believe the other side when they're also lying to you, which just continues to radicalize people. One would not know that the potential robber has a bullet in the chamber or a magazine in his pocket, even if there isn't a magazine in the gun. Plus, the intent is armed robbery, which is a felony. Yeah, this is what really pisses me off about this, because I have heard of cases where people went to bodegas and said, you know, I'm going to rob you. Stick them up. Well, who am I kidding? Robbers in Brooklyn don't do that. They do this. None of them actually hold a gun like this. They do this. Well, give me whatever's in the register. And there's no bullets in the gun. I'm glad you're attacking the policies rather than whether they're Democrats or Republicans. I mean, it comes back to intent, says Simplicity. If your intent is to rob me of money by using the threat of death, I don't believe that is a misdemeanor. And maybe that's controversial, but if you're looking to point a gun at me and the gun is not loaded, but I don't know it's not loaded, you're using the threat of death to get me to give you money. And at that point, I would prefer that you not be charged with a misdemeanor. Perhaps that's because of my political biases. Perhaps that's because I'm a business owner and not a criminal, so I would be on the opposite end of this argument. And perhaps that biases me beyond the ability to have a level-headed discussion about it. But I'll state my biases up front. Again, as a store owner, as a business owner, I would prefer that if you walk into my store and you have a gun and you do this and you say, give me what's in the register, give me all these MacBooks, and the police catch you after you leave, that when they catch you, that you not get charged as a misdemeanor just because you say, no, look, my gun was empty. Maybe I'm a dick. Maybe I'm just being the grandpa screaming at cloud. And a big part of it is just fundamentally not wanting to be a part of a society where we're just making these distinctions. Do I want to be a part of a society where we're saying, you know, okay, listen, I know that you went into a store. I know that you wanted to point a gun at somebody so that you could take their stuff. But because your gun wasn't actually loaded and you only deceived him into thinking you were going to kill him, we're going to let you off the hook. My gut reaction to that is fuck that on every level. I don't necessarily disagree with you about that particular situation being decreased to a misdemeanor, but few of the cases prosecuted under these guidelines would be that cherry pick scenario. Possibly, and again, I am a guy that fixes MacBooks that has no idea about the criminal justice process. I am just reading this and giving my thoughts as I go. I do not want to pretend that I have a clue what it is like to be an attorney, a defense attorney, an ADA, or a copier. Next time someone points a gun at you, Sonny says, just ask if the gun is loaded. It's like saying it's not investment advice. Okay, wait. Okay, let's go more with this. So if I ask if the gun is loaded and they say yes, do they no longer have the right for it to be moved down to a misdemeanor? I don't know. This seems like a meme at this point. All right. New subject. I covered this. I gave you my uninformed idiot's opinion, and you do with my opinion what you will.